Hvala, poštovani sude.
Thank you, Your Honors.
Govorio sam malo pre o generalu Ratku Mladiću.
I was speaking about General Ratko Mladić a moment ago and his status on the basis of the evidence adduced during the trial. Now I'd like to say a few words about Stanislav Galić, General Stanislav Galić, and the evidence related to his status. The prosecution did not refer to that at all. He was appointed to a duty that allowed him, as claimed by the prosecution, to be in a position to commit crimes as commander of the Sarajevo-Romania Corps on the 31st of August 1992. That is document D295 and D294.
On je takođe unapređen.
He was also promoted in the Army of Republika Srpska to the rank of Lieutenant General on the 7th of August 1994. This rank was never verified in the Federal Republic of Yugoslavia. He was pensioned off in the FRY in September 1994. As for the retirement of General Galić, just like all other generals, and the regulation of their status in service, on the basis of Article 151 of the law on the Army, it is the President of the Republic that makes the relevant decision, and it was President Lilić who decided on his retirement. General Galić was never appointed to any position in the VJ after his service in the VRS terminated.
Zatim general Milošević.
Then General Dragomir Milošević. I would like to say a few words about him as well, because the prosecution also analyzed his status. He held different positions in the Army of Republika Srpska from January 1993. That is, for example, D648 and D667. That's when he was in the Sarajevo-Romania Corps. From July 1993, he was Chief of Staff, and that is document D675. All the duties he had in that army were held before General Perišić was appointed Chief of General Staff of the Army of Yugoslavia.
Sorry, I'm hearing something. You say that's when he was in Sarajevo, Romania Corps from July 93 when he was Chief of Staff, and that is document D675. All the duties he had in that army were held before General Perišić was appointed. Oh, I beg your pardon. No, fine. Okay. So, but Chief of Staff, what do you mean by Chief of Staff? Chief of the main staff of the
We're back in open session, Your Honor. Thank you.
Thank you so much. Yes, Mr. Lukic.
General Milošević traži da bude
General Milošević asked to be pensioned off on the 26th of November 1996, and it is at his request that he is relieved of his duty and retired. That is P 1759. Until he was pensioned off, General Dragomir Milošević did not hold a single position in the army of Yugoslavia.
Sladoje Čedo.
Čedo Sladoje. At that time, he was a colonel.
Tužilac ga decidirano prvi put pominje.
The prosecution decidedly refers to him for the first time only in the final brief. He is not mentioned in the indictment, not even in the annex. During the trial itself, the prosecution did not adduce much evidence as to whether he was appointed or when to the 30th Personnel Center. As for his status in relation to the 30th Personnel Center, they are trying to prove that only through P738. That is that list of members of the Personnel Center, the 30th Personnel Center. There is no date, so we cannot see when Colonel Sladoje was appointed to that position. You are being asked to speculate. As for the activities of Colonel Sladoje, we did not hear a single word about that during the trial itself. Let us be quite frank, Your Honors. In the view of the defense, the prosecution did not consider Colonel Sladoje when they were preparing their case, when they were writing up the indictment, all the way up until the appeals judgment in the Dragomir Milošević case, when General Milošević was acquitted of the charges related to Markale II. That is incident A9 from the indictment, and that is the position of our defense.
When you say the prosecution did not consider General Sladoje when then they were preparing the case, are you talking about this prosecution or are you talking about the Dragomir Milošević prosecution?
O ovom našem slučaju.
Our case.
Da budem precizniji.
Let me be more specific. In the indictment, in relation to the officers that are referred to in Annex A, more specifically in relation to the Sarajevo-Romania Corps, there is a reference to Veljko Stojanović, and now in the final brief he has been left out completely. In the indictment, when the subordinate persons were referred to from the Sarajevo-Romania Corps, subordinated to General Perišić, as they put it, the indictment says other officers of the SRK. So if that means that the persons referred to in the indictment are defined in that way, then perhaps that might include him. However, that particular individual, Čedo Sladoje, was not someone that the prosecution was interested in at all during the trial. The prosecution did not exhibit any document related to him or related to his record. So we cannot, on the basis of their documents, tell from when he was allegedly a member of the 30th Personnel Center. However, the defense tendered a document related to Čedo Sladoje, and I would like to draw your attention to that document. D348. Could we please have it on our screens?
Ovo je jedna, da tako kažem sada, opet grupna naredba.
If I may put it this way, this is another group order. A decree of the President of Republika Srpska on the termination of service. Can we please move on to page 3? number 20.
Dakle, po ovom dokumentu koji...
According to the document you see now,
redni broj 20,
number 20,
Čedo Sladoje,
Čedo Sladoje, Lieutenant General in 2002, it says that he is serving in the General Staff of the Army of Republika Srpska at the point in time when his active military service was terminated. We assert that he never held any position in the Army of Yugoslavia.
Gvero Milan,
Milan Gvero. I will deal with him very briefly. We don't have to look at any documents, but I'm going to say what the evidence says. He was appointed to a position that he held throughout the war. As for this position he held in the Army of Republika Srpska, not in the Army of Yugoslavia, is quoted in Annex G by the prosecution, quite properly, as Assistant Commander of the Main Staff of the Army of Republika Srpska for Morale and Religious Affairs. That is what the prosecution says, and that's what we say too. That was already in December 1992. According to President Karadžić's decree, D698.
Nema u dokazima koji su izvedeni pred...
The evidence adduced before this trial chamber from personal records, including that of General Gvero, there is not a single document on any appointment of his to the 30th Personnel Center. Why? We can only speculate. But we do know that such a document would have to be passed by President Lilić, because this had to do with a general who was a general and was in the Army of Yugoslavia, or rather the JNA as well. He was relieved of duty in the Army of Republika Srpska, according to P1977, and he was put on the disposal of the VJ as opposed to General Mladić. That never happened in his case. However, although he was placed at the disposal of the VJ, until his retirement, General Gvero was never appointed to any particular duty within the Army of Yugoslavia, the VJ.
General Krstić.
General Krstić, who held various positions and held various ranks in the Army of Republika Srpska up until the 28th of February 2002, when he was discharged from duty by President of Republika Srpska. We have various exhibits to that effect: P2007, D119, P2008. They testify to the various positions he held within the VRS. These documents indicate that he was appointed to these positions by the individuals who held the appropriate competence to do so in the VRS. Now that we are dealing with General Krstić, I will make an aside in relation to General Živanović, which the OTP, whom the OTP has not been referring to directly, but there is a reference in their brief in paragraph 802, which says that General Živanović apparently took up a new position in the VJ. I think they even made an allegation to that effect in the indictment. I'm not sure. The allegation by the OTP is not consistent with the evidence adduced at trial. This is what the OTP is aware of. General Živanović was discharged from duty pursuant to an order by President Karadzic, D684. Thereafter, he did not hold any duty within the army of Yugoslavia. He was retired. It was a disability retirement, and there is proof to that effect, which is P2012, which the OTP simply ignored. Can we look at P2012 now? It's a document which relates to General Krstić, but look at the statement of reasons. The statement of reasons indicates that he will remove he will be replacing General Živanović, who is gathering medical documentation for disability.
We're back in open session. Thank you.
Thank you.
Hvala. Poštovani sude.
Thank you. Your Honors, what we have been examining in my submissions is related to our submission that you assess and examine the evidence in its totality. You need to cross-reference them and gauge them against each other up until you establish facts. I've given you I've referred to only a couple of documents by way of illustration, but of course this is an enormous task before you. If the prosecution claims that these individuals, by their membership of personnel centers, have had their status institutionalized as being members within the VJ at the time when the conflicts broke out, and that by that token Perišić was their superior de jure, then there is only one inference that you can make, only one finding that you can make in that regard. And I will go back to that when discussing effective control, because the OTP referred to these orders as proof of effective control. You cannot draw as the only reasonable inference, not even on the basis of the selection of documents presented by the OTP, and especially not if you regard the evidence in its totality, that they were within the chain of command of the Army of Yugoslavia at the time. We submit that at the time they were solely within the chain of command of their own armies, namely the Army of Republika Srpska and the Army of the Republic of the Serbian Krajina, because they were serving within these armies, as the OTP agrees, and as such they were within the superior subordinate relationships within these armies. This was the only and true superior subordinate relationship they were in. None of the individuals we refer to, or any of the individuals that the OTP referred to as responsible for the crimes in Sarajevo and Srebrenica, were at any point in time appointed to any duty or position within the Army of Yugoslavia. In order for them to be able to feature within the chain of command of the VJ, and in order for General Perišić or anyone else for that matter within the VJ to have them as part of the superior subordinate relationship as envisaged within the Army of Yugoslavia. Your Honor, I do not doubt that in making your findings with regard to the responsibility of Mr. Perišić in respect of aiding and abetting crimes in Sarajevo and Srebrenica, you will always keep in mind the case law of this tribunal and the way it defines this form of criminal responsibility as actions directed at assisting and providing moral support to the perpetrators of specific crimes which constitute substantial contribution to the commission of crimes. Only once you will have established beyond a reasonable doubt all these various elements will you be able to establish that elements have been satisfied for the actus reus of the accused in respect of the crimes he's charged with. And we claim that the prosecution has not adduced evidence or provided submissions that would enable you to arrive to that finding with respect to any of the actions by Mr. Perišić relating to their thesis on the provision of the officers' corps of VRS in assisting and aiding and abetting crimes in Srebrenica and Sarajevo. I would now like to go to the to deal with the other form of responsibility, namely that of command responsibility of General Perišić. In a number of legal arguments about command responsibility, both the prosecution and the defense referred to the same legal authorities. At the outset, I would like to remind you of what you must be aware of, regardless of the submissions we make in our briefs, and which we think is relevant in assessing the evidence and arriving at findings. The theory of command responsibility has been pretty much crystallized through, among other things, the jurisprudence of this tribunal. The case law has provided answers to many issues that have now become part of the standards and part of the international customary law. One of the positions that are frequently referred to from the ICTY case law has been formulated in the Celebic appeal judgment at paragraph 303, and I will repeat it, although we must all know it by heart now. There, the idea of command responsibility is construed as responsibility of persons who, by virtue of the position they occupy, have authority over others. But that idea of command responsibility has not been intended to impose liability on persons of equal status. That is the motto or the guiding idea that we all follow when dealing with command responsibility. The two main legal issues concerning command responsibility raised by the prosecution require that we respond to them. At transcript page 14678 and 14679, in relation to what Madam McKenna said, we as a defense believe that both sides in a superior-subordinate relationship need to be aware of the existence of this relationship, whereas the OTP contend that the only parameter of the existence of this relationship is effective control. We continue to hold the position that both parties need to be aware of the existence of a superior-subordinate relationship in order for there to be one. The superior-subordinate relationship is a personal relationship between two individuals. And in our view, one of these individuals, and that's the subordinate individual, needs to be aware of the existence of the relationship. The OTP has been building their thesis on the de jure relationships within the army, on what is provided by the law. It is inconceivable of the army being operational without the subordinate knowing who his superior is. Of course, he doesn't need to know who all of his superiors up the chain of command are. He needs to know who his immediate superior is, or possibly who the second or third up the level is. Command responsibility as a form of responsibility can be workable within an army only if the individuals involved are aware of the rules of the game. The prosecution has used the standard of effective control frequently, and they want to use it roughshod over all the other elements that may arise and that may be relevant for the determination of effective control. And this is a very dangerous approach, because we know that effective control exists even outside of a superior-subordinate relationship, and we've got many examples from the ICTY case law to testify to that. The superior-subordinate relationship is a relationship between two individuals, and also the insubordination, or the duty to obey the superior's orders. And the test of effective control can only be an element that is important for the determination of it. Certainly.
Page 66, line 8, the translation reads insubordination. Is that what you said? Doesn't seem to click with that the rest of the sentence. Subordination would, but not insubordination. No. I don't know. I'm not sure.
Da, subordination, you know.
Thank you.
Ja sam i ovaj tim odbrane, i to je ono što juče gospodin Gajs.
This is what Mr. Guy-Smith said yesterday, that he envied your position. I didn't find it established within the ICTY case law in no uncertain terms. The position with regard to aiding and abetting. About the perpetrators not needing to be aware of aiders and abettors who may be accused in a case. I'm drawing a parallel here.
I'm just saying I didn't understand Mr. Guy-Smith yesterday on that point. I'm sorry for being slow on the uptake.
Ja sam ga shvatio. Ja sam ga shvatio.
My understanding of what he said is, and I may be mistaken, is that since this is a unique case, you will be faced with a challenge that places you in a very in a position of great responsibility, as does all of us. In relation to aiding and abetting, the ICTY case law says that the perpetrator himself need not be aware of the existence of an aider and abetter. Now, what we are discussing here, and what you will have to make a final finding on, is that we haven't found a decision rendered by this tribunal to that effect, but we found it elsewhere. So I will call you to look at a case of the State Court of Bosnia and Herzegovina, which we are all familiar with. The State Court of Bosnia and Herzegovina frequently relies upon the ICTY case law as part of international law now. There are two judgments. One is that of the appeals judgment in the Manic case, Article 107, or paragraph 107. And the other speaks quite directly about the position we have taken. This is the Todorić-Rašević trial judgment, paragraph 148. This is legal theory turned into case law. Let me conclude.
Rašević and Todović, or Todorović. I only had the first instance decision to refer to. In order to conclude, I wanted to say that your microphone was off, but I believe you wanted to know the paragraph. It is 148. Let me check. Yes.
Last question before you go. Can we find it in English?
Yes, I think you can in their database.
Thank you.
Dakle, zaključujem vezano za ovo pravno pitanje.
Concerning this legal matter, it is our position that both participants in a superior-subordinate relationship have to be aware of the existence of that relationship, especially within military structures. Let me add another thing. This same prosecution in earlier cases asserted that there was a presumption of the existence of subordinate-superior relationship in military structures. I believe it was in the Hasanović or Halilović case, and it was found insufficient. Another important issue raised by Mr. Harman at transcript page 14751 and 14752, in which he asserts that the defense need not make a distinction between the singleness of command and effective control. They refer to the Popović judgment, paragraph 2025 and 2026. It is a recent judgment. He relied on that source to corroborate his thesis that singleness of command does not equal effective control. We, Your Honors, believe that the analysis carried out in the Popović case that Mr. Harman relies on is completely inapplicable in our circumstances because it makes a distinction between effective control and the singleness of command within the same chain of command. It was the relationship between Vinko Pandurović as brigade commander and Mr. Obrenović as his chief of staff. In that regard, the relationship was analyzed, trying to see that while he was not in the position of commander, standing in for the chief of staff could have exercised effective control. And the defense relied on the principles of singleness of command. We are in a different case here. The OTP themselves assert the existence of two parallel chains of command, not a single one. In that regard, I wish to draw your attention to the separate opinion of Judge Kwon on this topic as part of the judgment I referred to, as he puts forth in paragraph 50 of his opinion, because I believe it tallies completely with our interpretation as stipulated in paragraph 73 of our brief. These are two legal matters which will obviously pose a challenge to you in this case. We also wish to draw your attention to the distinction between influence and control. Mr. Guy Smith addressed it briefly yesterday, and Mr. Harman did not mention it at all. This defense team is deeply convinced that this case is the best example of the difference that needs to be drawn between influence and control. This is the case which can openly and crystal clear show to us the extent of influence, when it exists, when it does not, when it is exercised, without reaching the threshold of control. Based on all evidence presented, you cannot establish beyond a reasonable doubt that there was effective control that crossed that threshold. By virtue of that, you cannot conclude that there was the relationship of superior-subordinate between Mr. Perišić and those designated by the prosecution as crime perpetrators. When analyzing the relationship between influence and control, please bear in mind that in this case, we move within the boundaries of a clear set of the way the game is played. There was a single chain of command, and we know how it worked. Before I move on to the issue of influence itself, I wanted to mention another important thing, and this is where we differ from the prosecution. However, they did not mention it in their final argument, but they did in their final brief. We have opposing tribunal jurisprudence in that respect. We assert as we put forth in paragraph 80 of our final brief, we support the jurisprudence confirmed in several cases, including their appeal phase before this tribunal, which states that the liability of the commander can exist only if there was effective control over the perpetrators at the time crimes were committed. We are aware of the existence of two appeals with different positions, and this is ours. Only at the time of the crimes, there must be effective control.
Sorry, the stenographer didn't hear me. I was saying, can you cite us all three judgments? The one that you go with and the two that go against you.
Možda je loš bio prevod.
I don't think I mentioned three. There were several. However, there are two on appeal that are contradictory, and I will refer to them.
Okay. Samo sekund.
Please bear with me.
Tako je. Halilović, samo sekund.
Halilović, just a second.
Tako je. Presuda Halilović.
The judgment in the Halilović case. Paragraph.
Prvo čitam prvostepena.
First, the trial judgment, because I have a few references. Perhaps not to complicate things, I can tell you that it is all in our paragraph 80, footnote 130 of our final brief. Perhaps that is the simple way to go about it. These are the references we invoke to support our arguments. The opposing position was taken in the Orić case and the appeals judgment, and I believe the OTP relied on that. Interpreter's correction, footnote number is 131.
Samo sekund.